Chapter 2, Leasehold and property interest other than the ownership. So in this chapter, we're going to talk about the difference between the commercial and residential tenancies. We'll discuss topics involving creation and essential elements of lease, including assignment and all subletting. We'll discuss topics involving commercial tenancies that are commonly encountered by practitioners. We'll identify the main characters of easements and non-ownership interests, and we'll apply concepts involving leasehold and other property interests to typical situations encountered by real estate practitioners. So, the the first topic is commercial versus residential tenancies. The line between commercial and residential tenancies are found out by legislative consideration impacting both landlords and tenants. So, the way to look at it is a, a commercial lease can be identified as any lease involving a property that is principally used as for a business activity. The operative word is important. Essentially, what is the principal use? For example, a small house home office within a residential structure would not affect the residential status of the property. A residential containing a main level commercial enterprise and two upper level apartments would be identified as also as a commercial unit for the lower unit, and the residential for the upper units. Practitioners should normally determine if the property is residential and subject to Residential Tenancy Act. Normally, certain hybrid situations can cause, for example, let's say you have a 30 acres of rural property, and that includes renting the barn and the balance of the property as a riding stable. So, if an individual occupied the home prior to the riding stable operation and lease the business operation under a separate lease, then the Residential Tenancies Act would apply to the residential tenancy. But if the person occupied the barn for riding stable operation and his sole residence under a single lease, the property would be classified as a commercial purpose because the occupancy of house was required to carry on that particular business. So practitioners should be aware of the exclusion for certain type of rental arrangement, for example, like living accommodation intended for traveling or vacationing public. Occupied for a seasonal or temporary period is excluded under the Residential Tenancies Act. The exclusions include living accommodation when occupancy is conditional on the occupant continuing employment to a farm, and the living accommodation occupied by non-profit housing cooperatives for two tenants in the member unit, and those which are governed by selected legislation like the Public Hospitals Act, provided as an emergency shelter or provided by an education institution, and also like the living accommodation located in a building on a project, and the occupancy is required into the function performed by the tenant in that building or a project. So these are some of the exclusions for the Residential Act, or RTA. So the other exclusions also include like the living accommodation where occupants are required to share a bathroom or a kitchen facility with the owner, and premises occupied by the businesses or agricultural purposes with living accommodation attached, and also select type of living accommodation provided for the purpose of receiving rehabilitative or therapeutic services. So coming back to the instrument of lease. So what is a lease? A lease is a contract between the landlord and the leasee for the occupation or the use of the landlord property by the leasee for a specified time and for a specified consideration. Under the term of the lease, the lawful owner of the property the landlord transfers right of use, ownership, and enjoyment to another for a specific period of time or at will for a consideration. The lease may also be referred to as a tenancy agreement. The purpose of the lease is to establish a written record of agreement between the parties for a living arrangement within a defined period. A lease can be verbal or written, express or implied. A lease document, whether residential, commercial, or industrial, is a detailed document setting out the responsibilities of the parties, rents payable, and obligations of both landlord and tenant, along with a wide range of all provisions concerning notices, remedies, and of termination. Assignment. An assignment involves the assignment of right, ownership, and interest in the lease, whereby the signer or leasee transfers the entire remainder of the term created by the lease. A tenant or the signer, a signer may transfer all of his leasehold interest to a new tenant, but unless he or she is released by the landlord, the signer remains liable for the lease obligations. To the landlord, it should be noted that the signer may not remain liable for performance under the lease if such is specifically set out in the terms of the lease pertaining to the assignment. If a tenant transfers something less than the entire interest, he or she sublets it. This may be either the subletting a part of the term or part of the premises. Again, the tenant remains liable to the landlord unless otherwise stipulated in the lease. A tenant may assign or sublet at will without the approval of a landlord unless the lease stipulates otherwise or a provincial legislation establishes entire certain requirements or procedures. In fact, most leases contain an express covenant that the tenant will not assign or sublet or a qualified covenant that there will not be any assignment or subletting without the prior written consent of the landlord. This clause may be further qualified so that the landlord consent may not be arbitrarily withheld. In these circumstances, the landlord can apply to a judge to obtain approval for an appropriate tenant who intends to use premises in a reasonable manner. Unless both tenant and assignee or the subtenant will sign a form agreeing to be bound by the main lease and the landlord will consent to the agreement, the parties will pay landlord reasonable costs in arranging for this consent and will include any legal expenses. This may be There may be other requirements concerning subtenants for residential tenancies in government subsidized housing or government owned projects. Creation registration. A lease can be written, verbal, express, or implied by the person conduct. Its terms are found in the common law and the provincial statutes concerning commercial residential tenancies. Normally, the parties will enter into written signed lease agreement or tenancy agreement in order to precisely describe their relationship. A wide range of lease forms and stated wordings are found in the marketplace. When the property owner agrees to lease the property, the tenant acquires an interest in the property and may register the applicable documents in the land registry office giving the notice of this interest. Methods will vary based on whether the property is registered under the land titles or registered upon specific registrations set out the individual provincial jurisdiction. Elements. Lease form differ substantially, but whether for residential or commercial purposes, all must contain the following elements to make them legally enforceable. Statement of correct names and signatures of legally competent parties. Full legal name. The person signing must be competent. The legal description of the lease premises. Consideration that the exchange of something of value. A lease must also include a description of the legal purpose for which the premise is to be used. By virtue of this clause, the tenants can be controlled in a particular type of business being carried out, thereby permitting exclusive use within the retail complex and by providing assurance that other tenants would not be in the direct competition. Now, there are some more details that we need to talk about. Essentially, what is more towards the history of a lease. For centuries, the law recognized freehold interest as a property interest and permitted only a person who possessed freehold estate to bring an action to protect his real estate. All other interests are less significant and considered personal in nature. The introduction of leasehold interest into law and increasing use of this land holding method required change in the legal concept. Leasehold became known as states that are less than freehold but are states nevertheless. One major distinction between freehold and leasehold estate is that while both are a measurement of time, the freehold is for uncertain time, whereas the leasehold is for time that is certain and capable of being made certain. In the in the case of feudal doctrines and concepts, the relationship between landlord and tenant is of major significance. The court have called upon to decide disputes between the two, and the results often favored the landlord by strict interpretation of the principles of land law. Land and its right to occupancy were the major assets of most aristocracy, and the land was prized for the wealth and the power it bestowed. In the simplest form, a lease is a grant of interest in the land. In practice, it's usually a grant by the way of contract, whereby the owner, called the landlord, transfer exclusive use and possession of real property to the other person called as the leasee or tenant for a period of time called as term, and for valuable consideration called the rent. While there are other requirements in the lease, the most important aspect involves granting of the exclusive possession. In the parties contract for something less than that, if the parties contract for something less than that, the right may not recognize the arrangement as a lease, but as some other legal personal arrangement, such as a license. The distinction has a practical significance in that the leasing may enforce entitlement to rights against a subsequent owner, while a license may not be able to do so. Therefore, a contract that may not grant exclusive possession is not a lease, and the occupant does not have the right to exclude all other persons from the said premises. Such contracts may involve mall kiosks and residential rumors or borders. The latter can be complex since the landlord and tenant law historically do not consider rumors to be covered by specific legislative uh, I'm sorry, the residential rumors or borders can be complex since the landlord and tenant law historically do not consider rumors to be to tenant, whereas modern statutes such as those of rent control may consider them to be covered under specific legislative provisions. In a leasehold arrangement, the landlord retains an interest called as the reversion. The tenantry state is lesser one than that of a landlord. If it's otherwise, then the arrangement would be a transfer of the entire interest and constitute a sale. Landlord, a person or a company who holds tenantry real property is referred to as a landlord. The specific statutory definition of a landlord is a person or a lessor, a person giving permitting the occupation of premises in question, and these persons here as assignees or legal representatives. Offer or agreement to lease. An offer sets out the material terms regarding the proposed tenancy agreement between the landlord and tenant, and once agreed by the parties, becomes a reference document for drafting the lease. In most lease transactions, the practitioner will be known in two steps. An offer to lease is signed, setting out the basic terms for the agreement between the parties, and the offer to lease flow into a detailed lease agreement that must be signed by the parties. Practitioners frequently attach pre-printed blank lease to the offer as assurance that all parties are aware of the terms set out in the agreement and will be subsequently signed. Sublet practitioners should clearly differentiate between subletting from assignment. When the entire interest is transferred, it's said to be assigned. When the tenant as a signer may transfer all of his interest to the new tenant, the assignee. The original tenant remains liable to the lease obligation to the landlord. A general As a general statement, a tenant may assign or sublet at will without approval of the landlord unless the lease stipulates otherwise. In reality, most commercial leases contain an express covenant that the tenant will not assign or sublet, or a qualified covenant that they will not be assignment or assignment or any subletting without the prior consent of the landlord. This clause may further qualify that the landlord consent will not be held arbitrarily. If this occurs, the tenant may be able to apply to a judge and obtain approval for an appropriate tenant. Usually, both tenant and the assignee and the subtenant will sign a form agreeing to be bound by the main lease, and the landlord will consent to the agreement or a contract. The parties will pay landlord reasonable costs in arranging for this consent, including the legal expenses, credit investigations, and similar expenses. Subletting provisions apply to all tenancies, whether periodic, contractual, statutory. The Resident Tenancy Act sets out various requirements and restrictions concerning subletting. Subletting provisions do not apply to the tenant of a subtenant premises. The tenant may sublet with the consent of the landlord for its term ending on a specified date before the end of the tenant terms, giving the tenant the right to resume occupancy after that date. The landlord cannot arbitrarily and unreasonably withhold consent to a sublet. The landlord may charge his out-of-pocket expense relating to the consent. The landlord remains entitled to the benefit and liable for breaches under the tenancy agreement during the subtenancy period. The subtenant is entitled to the benefit and is liable to a tenant for the breach of subtenant obligations. The subtenant has no right to occupy the rental unit. After the end of subtenancy, the tenant may apply to tribunal for an order for compensation from an overholding subtenant if the subtenancy is in possession of the rental unit at the time of the application. Various rights given to the landlord concerning termination apply to the tenant. If subtenant overholds and the original tenant has vacated the rental property, the landlord has 60 days of discovering the type of occupancy, negotiate a new tenancy agreement, or apply to a tribunal for an eviction order. Unauthorized occupation can be deemed to be an assignment if the landlord consents, or rather, the unauthorized occupation can be deemed to be an assignment if the landlord consents if a new tenancy agreement is not entered in 60 days or no application is made to evict the person or the subtenant. Now, moving on to the commercial tenancies. Commercial tenancies can generally be described as any property subject to the leasehold interest that involves land or building used for business activity. Commercial tenancies are governed by the provision of Commercial Tenancy Act. The name of the act was previously Landlord and Tenant Act, and it has like part 1, 2, 3, 3, which was formally changed in 1997. Part 4 of the Landlord and Tenant Act was repealed and replaced with the Tenant Protection Act, which was in turn replaced by the Residential Tenancies Act. So the commercial tenancies are kind of a bit complex. Commercial tenancies are inherently diverse and require specialized wordings relating to industrial, office, retail, investment, and vacant land leases. Requirement concerning such tenancies require interplay of legislative as well as legal precedents. In fact, debates concerning commercial leases can require detailed review of legislative requirements, principles set out in contract law and the case law dating back to 19th and 20th century. The structure of the Commercial Tenancies Act is somewhat disjointed in comparison to the residential counterpart. Like for Part 1 generally addresses the landlord-tenant relationship, Part 2 focuses on restraint for areas in Rand and Part 3 concerns overholding tenants. This text includes a limited set of topics commonly encountered by the practitioner. Salesperson and brokers seeking additional information are advised to consult appropriate legal counsel. Fortunately, commercial real estate is heavily influenced by national and international practices. Consequently, a wide range of commercial leasing terminologies are used in the marketplace. Selected topics are included in this course book for descriptive purposes. Practitioners are reminded that no standard commercial lease wordings are used in Ontario and that every real estate transaction is unique. Assigning and subletting. The legal decision between assigning and subletting a commercial lease is on based on a privity. A privity generally refers to the legal proposition that a contract, including the right and obligations, is only enforceable upon the parties to that contract. Privity generally essentially means that the contract, including the right and obligations, is only enforceable upon the parties to the contract. Practitioners need not fully understand legal complexities associated with assignment, subletting, and privity, but should be aware of the basics. At the end of the lease term, the tenant is required to reconvey the leasehold estate to the owner of the freehold. This creates a privity of estate between the tenant and the landlord. If, for instance, the tenant assigns all of his lease to a third party, then the third party known as assignee establish a privity of estate with the landlord. The former tenant or signer of the lease has no privity of estate remaining with the landlord. On the other hand, if the tenant conveys a portion of the leasehold estate to a third party, such that the tenant retains a period of time at the end of the term, then the tenant remains in a privity of estate relationship with the landlord. The subtenant so created would have no privity of estate with the landlord. In a contractual context, if a tenant sublets his premises, no privity of contract exists between the occupant, subtenant, and the landlord. Therefore, the landlord will not have any legal relationship in the form of privity of estate or contract with the occupier of the premises. However, the landlord retains his privity of contract and estate with the original tenant. Accordingly, the lease normally provides that the subtenant must directly covenant with the landlord in order to ensure that the landlord may then pursue legal action against the tenant or the subtenant. But with an assignment, the assignee and the landlord may have priority of contract, provided the assignment to assignee includes the language to the effect that all of the benefits and burden of the lease are assumed by the assignee. In that case, the obligation to the landlord flow to the landlord, and priority of estate continues between the landlord and the assignee. The landlord then retains the priority of contract with the original tenant unless otherwise agreed. Landlords should be careful in preparing the assignment and subletting provisions of the lease. In first instance, the landlord should require that any assignment or subletting is subject to the landlord's consent, and that the new party, be it assignee or a subtenant, must agree to the covenant directly with the landlord with respect to the subtenant's obligation to the lease. The landlord is entitled to withhold its consent but only on reasonable grounds. For that reason, many commercial leases allow the landlord, when faced with assignment or sublet situation, to terminate the lease. This gives the landlord certain control over the premises, particularly in a strong market. The rent chargeable at the time of the assignment or subletting is substantially higher than currently being paid by the existing tenant. Further, the landlord often includes a provision whereby the tenant is not permitted to sublet or assign the premises and receive rent higher than what would otherwise be payable to the landlord pursuant to the lease. The lease, from the landlord perspective, should not be in a position, or the tenant, from a landlord perspective, should not be in a position to obtain extra funds from the demand should the demand of the rental space increase after the execution of the original lease. The landlord should also take care at the time of assignment or subletting to ensure that adequate documentation is in place to obtain sufficient covenants from the new assignee or tenant, as well as preserving the right to pursue any or all legal remedies against the original tenant. Continuous use. A continuous use clause requires that the tenant must continuously occupy the rented space during the occupancy of the lease. Typically, a continuous use clause is accompanied by covenants that the tenant will maintain a substantial merchandise stocks and fully staff the operations. Landlords are increasingly concerned with dark spaces. If a lease does not contain a tenant use space, the tenant may move out of the premises while continuing to pay rent. A landlord may be left with dark space in the retail center, which he cannot relate to a third person. So this is one of the ways in which the landlord for of a commercial premises is going to make sure that there's enough of foot traffic in his commercial in his commercial space that he's leasing. Now, in case of anchor tenant, may also use this technique to control the marketplace, more notably in small and urban, in rural areas. If, for example, there are two malls servicing a community and a largely outlet space in both the malls, then the tenant may leave on dark and essentially control the retail marketplace in the community. So the landlord with the dark space is left with in an uncomfortable position of leasing to other tenant in a mall which is not attracted to the lack of the anchor. So therefore, a carefully drafted continuous use clause provides the landlord with the option to prevent such a scenario. Guarantor was indemnified. A third party guarantor or indemnifier undertakes to be responsible for tenant obligation upon default. Real estate practitioners involved with commercial leases often encounter landlord requirements concerning guarantor was indemnifier. So essentially, a guarantor is a kind of a limited in scope because a simple guarantee is not sufficient because a simple guarantee has obligation or tenant and tenant becomes bankrupt, then the guarantor is not required to pay as the tenant is no longer has liability pursuant to the lease. In recent years, indemnities have grown in popularity. This arrangement provides that the indemnifier agrees to indemnify and would harmless the landlord against any damages that may result from the tenant's failure to perform his or her obligation pursuant to the lease. Indemnity agreement normally go further and imply that the indemnifier is a covenanter pursuant to the lease in the same sense as the tenant and his and this indemnity survives any bankruptcy and insolvency of the tenant. Such agreement also typically provides that the indemnifier upon failure of the tenant to perform the pursuant to the lease is deemed to be the tenant and subject to all the covenant contained in the lease. So another way to protect the landlord is the concept of co-tenancy. Essentially, the proposed guarantor becomes a co-tenant with the tenant and is jointly and severally responsible for obligations of the tenant pursuant to the lease. The landlord can then look to the subtenant in case of bankruptcy and insolvency of the main tenant. Interest on rent deposit. Under the Commercial Tenancy Act, a landlord is not required to pay interest on the commercial tenancy security deposit. But a lease agreement may require a landlord to pay interest on the security deposit or on the last month's rent. Landlord, for the purpose of the Commercial Tenancy Act, the landlord is deemed to include a person who is a lesser owner or the person giving or permitting the occupation of the premises in question, and the person here is assigned or legal representatives. In Part 2 and 3, the landlord also includes the person entitled to possession of the premises. Landlord. A lease is a contract between the landlord and the tenant for the occupation of the use of landlord property. Lease versus agreement of lease. An agreement of lease is technically referred to as an agreement of lease without a settled form of lease. An agreement to lease generally sets out the fundamental material aspect of the agreement between the parties, but contemplates the execution of a formal detailed lease. The agreement to lease covers substantial issues and is best described as a consensus leading to the final agreement. Practitioners, while drafting agreement to lease, must ensure that all essential elements of the lease are included, namely the parties, the description of the premises to be leased, the commencement of the lease, the term of the lease, amount of the rent, all other material matters in the lease other than the specific exemptions, reservations, and covenants are implied by law. The agreement of lease must also address all the other material issues in order that a lease can be currently drawn as a consequence of the agreement. Serious persons are well advised to ensure that every agreement of lease is complete in all aspects. Any confusion can result in a legal ramification. Fixtures or trade fixtures. Commercial tenancies often refer to tenant fixtures as trade fixtures. The general theory of common law is that any fixture belongs to the person who owned the real estate. That is, the landlord would own the building, and the landlord would also own any fixture that became part of the building, whether that fixture was placed by a tenant or not. Common law further developed to permit the tenant to remove such fixtures from the real estate as when necessary for it to conduct its business. Such fixtures became known as over time as the trade fixtures. Unless the lease states otherwise, a tenant who affixes an item to the reality is entitled to remove that item at the end of the term. The difficulty arises if that particular item may in one situation be a trade fixture but not another. Example involves a sink in the barber shop. Most leases provide that any fixture fastened to the real regular property of the landlord at the time of fiction. After the lease is expired, provided all the rent has been paid, the tenant may remove only trade fixtures. Landlord may insert a provision in the lease to ensure that the tenant may not take goods unless all the rents have been paid. Also, landlord may provide that in the lease that the tenant or the landlord's option may be required to bring the premises back to the original condition at the end of the lease. This represents a substantial lever for the landlord at the end of the term, as the necessary repairs may be costly for the tenant. Tenant may exercise caution must exercise caution regarding such provisions in the lease and should be aware of the costs associated with the removal of items at the end of the term. Commercial lease also provide that the tenant repair the premises when tenant fixtures are removed at the end of the term. Further, a lease may include a provision outlining the implication of the tenant after leaving the goods on the premises for any considerable period at the end of the term. License versus a lease. A license is a right of permission granted to the individual, while a lease is both a matter of contractual arrangement and also a conveyance of estate and land. The issue of license versus lease is best illustrated by the concession in the retail shopping mall. Disputes may arise as to whether the tenant or the landlord may seek legal remedies pursuant to the Convention Tenancy Act, as well as case law in the case of support of landlord-tenant relationship. Often a concession stand within the common area of a mall or within a large apartment area is not granted exclusive possession, and the business is simply located in a particular spot, subject to the landlord's rights and ultimate control. While such matters fall to judicial interpretation, the court generally look to the issue of whether the exclusive possession has been given and whether signed agreements are couched in terms usual to the lease, landlord, lessor, tenant, lazy lease, or demise premises. However, many other factors may also be impact on this. In the case of non-payment of rent under the Commercial Tenancy Act, there are two options. Option one is to change the locks. The landlord may change the locks of the unit and evict on the 16th day after the rent was due. For example, the rent was due on January 1st, and on January 17th, the lock can be changed without notification. And as a cautionary note, landlord and tenant should not force their way into the premises. Also, after the locks have been changed, the landlord should allow tenants reasonable access to the rental unit to move their property. Option two is seize and dispose of the tenant property. A landlord may seize and dispose of tenant property that is contained within the rented premises. Landlord is not required to give advance notice of seizing tenant property unless the lease provides for such notices. However, landlords are required to notify the tenant of the distress, and the sum of money is required to cure the default before proceeding to seize the property. Again, with the seizing, there's a requirement of a 5-day hold period. Essentially, landlord is not permitted to sell the tenant property during the 5 days. By disposing of tenant property, the Act requires at least two appraisals. Proceeds from the disposal of tenant property are to apply to the rental areas. In the event the amount proceeds exceeds the amount of rental areas, and the money should be returned back to the tenant. Certain amount of tenant property cannot be seized, like property that is leased or co-owned. Subtenants who continue to pay the full rent cannot have the property seized, and also like commercial tenants who wish to dispute their then action should apply to the superior court. Now, with regards to the quiet enjoyment, this clause provides a non-defense by the landlord when the tenant occupation of the premise which generally protects the tenant from any direct or indirect action or threatened action by the landlord. And practitioners should be aware, should exercise due caution in all the matters concerning the topic. Like quiet enjoyment does not normally mean undisturbed by music or other disturbances. If the landlord effectively deprives the tenant of the use and enjoyment of the rented premises, the breach of covenant can result. Rent increases, like Commercial Tenancy Act generally has no stipulation. So any commercial tenancy agreement may outline details such amount of and the frequency of rental increases, but the Act does not regulate what sort of rent increase is possible. Regarding the restrictive use, a restrictive use clause within a lease limits or in some way restricts the activities of either the landlord or the tenant pursuant to the lease agreement. The landlord may insert a restrictive covenant regarding the specific use. For example, a retail establishment may be permitted to sell donuts but not sandwiches. Essentially, landlord may typically introduce restrictive clauses to ensure proper mix of tenant. Restriction may also be more specific to address the particular makeup of a trading area. In some instances, tenant may also request exclusive use, particularly in a shopping center context, to better ensure business volumes to protect the tenant interests. Such clause should apply to the lease term and any renewal thereof, apply for the apply to the benefit of the premises to be enjoyed by the assignment of the tenant and apply to any expansion of the shopping center. So again, these are some interest, some ways to protect the tenant interest to ensure that if there's any exclusive clause that is set, then make sure that it applies to the lease term and any renewals as well to the benefit of any, and it's applied to the benefit of the premises. So the assignment can happen and apply to any expansion of the shopping center. Any rights and obligations. Landlord have the right must landlord must notify tenant in writing of specific breaches, have the right to terminate a tenancy when the tenant fails to fulfill obligations, has the right to apply to Superior Court to seek damages for less than 25%, $25,000 for to small court, otherwise it goes to a Superior Court. Signing authority. Commercial leases usually provide involved in corporation, partnership, and other circumstances, associations, and societies. In each case, the care should be taken to ensure that such organizations have authority to enter into contractual arrangement with the appropriate individual who you have signed the lease document. Corporation may be restricted in their ability to enter into leases either through incorporation document or by statutory restrictions. Partnership also may have partnership are typically bound jointly and severally to obligations entered into the partnership. Association societies may be limited by their incorporation documents. Now, in case of termination, if it's a month-to-month lease, under the Act, either the landlord or the other tenant may terminate a month-to-month tenancy with a minimum of 1 month written notice. The last day of tenancy should be the last day of the rental period. For example, on March 31st, written notice deliver one party or the other, the next rental period becomes April 1, and the tenancy can be terminated on April 30. The written notice termination should include the landlord's name, tenant's name, address, and description of the rental property, a date of the tenancy should terminate, and the date of the notice is served. In this case of a month-to-month tenancy, in case of a fixed term, the fixed term tenancy agreement specifies specific length and term of the lease. Under the Act, once the tenancy ends, the tenant no longer has the right to occupy the premises. For example, under a 3-year lease agreement, the tenant is expected to leave the premises at the end of 3 years. If the tenant continues to occupy the rental lease premises after the landlord has requested that the tenants move out, then the tenant may be subject to penalty of 2 months rent for every month they remain on the premises plus the applicable cost. Trading fixtures. Trade fixtures are articles installed by the commercial tenants, subject to the tenant's business and removable by tenants before the lease expires. Under the terms of the lease, trade fixtures typically remain personal property and are not true fixtures. In commercial leases involving new premises, landlord will normally have developed design of the building, landscaping, and common areas, and established the element of the areas to be leased, such as washrooms, electrical devices, HVAC. The balance of the work is to be completed usually with the tenant's cost and subject to landlord's approval. All alteration, additions, and improvement made by the tenant, landlord on behalf of the tenant becomes the property of the landlord, provided that the tenant should be responsible for ensuring of other effects, alterations, decorations, additions, or improvements. Coming to the easement, an easement is a right enjoyed by the one tenement over the another tenement. For example, one landowner will with the right over the another landowner, usually granted by a special purpose rather than a general use and occupation of the land. An easement is an interest that runs with the land. So once granted, then easement attaches to the land and binds a subsequent owner. So just looking at the typical easements that are there, um, there's a party wall easement and the right of way, which are important. So essentially, a party wall easement happens when especially in the case of case of two building units which share the same wall. So the agreement will declare the dividing wall between the dwelling units as a party wall and set out the right privileges, easement, and covenant that exist in respect of the party wall. These will usually be the same for both the parties. Therefore, the party wall agreement is subject to mutual easement. Again, the legal descriptions and characteristics of party wall vary by provincial jurisdiction. The right of way is another easement which is frequently encountered. So essentially, right of way over a land is of another, or make use of designated strip of land. So it is essentially Right of way is essentially an easement that includes the right to enter upon the land of the Serbian tenement. The dominant tenement enjoys the right of way over the Serbian tenement to which the easement applies. For the purpose of maintaining the easement and making repairs, as in the case involving public utilities such as telephone, railway, telegraph, or gas and oil rights. Often such right of way is referred to as statutory easement if the right is created by authority of a statute like Public Utilities Act or Pipeline Act or the Power Corporation Act. So a practitioner got right of way, particularly in the listing of rural and recreation properties. An easement can be created whenever an owner decides to grant a privilege for the right of way in favor of the adjoining property owner. An easement is obtained for a special purpose rather than for general purpose and occupation of the land. An easement expressly granted can be for a limited period or it can be granted forever. In the latter instance, once right of way is granted, it runs with the land and will pass on from owner to owner. When listing properties, an easement must be clearly identified and described. So essentially, in an easement, there is a dominant tenement and there is a subservient or servant tenement. Dominant tenement has right of way over the land belonging to subservient tenement. Now, the creation of a easement can be through an express grant. The easement can be created whenever an owner decides to grant any privilege, given to a prescription. The individual can obtain the right of way or easement by adverse possession, also known as prescription or squatter's right. Can be implied. Two types of implied grant exist: right of mutual support and right of way by necessity. Implied is naturally inferred right due to some related circumstances with mutual support or shared docking area with access right by both owners could generally preclude the ability of one owner to destroy his or her portion of docking unit to detriment of the other. In the urban setting, this would apply in semi-detached units. The second form of implied grant relates to the right of or right access and right of way that necessary for reasonable enjoyment of the property. The essential elements of implied grant involves the right used by the owner uses right of way as though it's apparent to the property. Use was both apparent and continuous, and right of way was necessary for reasonable and convenient use of the property. And statute easement created by the statute involving groups such as public utilities and telephone companies, which gain right to string wires, install equipment, and maintain service by the virtue of various provincial statutes. A statutory easement is created by the authority of the statute and does not require a dominant tenement. So again, the creation can happen through express grant, through prescription, through implication, and through statute. Registration. An easement is most commonly registered on title by inserting the appropriate reference in box 7 of the transfer deed of land. Detailed description can be attached by way of schedule. A document journal is required to delete the easement from a property. Again, it's important that the easement is described in details using maybe using metres and bounds. And the purchaser agrees to assuming encumbrance such as easement that are described from the agreement. So again, the agreement of purchase and lease contemplates the existence of easement, which is provided that the title of the property is good and free from all registered restrictions. Now coming to the non-owner easements. Now, in the case of non-owner easement, there are appurtenances, which are non-owner ownership interest that goes with the property. That's right of way. There can be encroachments, which are unauthorized intrusion into the land or property by one individual over that of the other. Encroachment agreement permits the encroachment of an improvement over adjoining parcel of land that may be registered against the title of both the parties and affected by the encroachment. Encumbrance is an outstanding claim or a lien recorded against the property and an illegal right to the use of the property by another person who is not the owner. Lien is a right of encumbrance affecting any property, generally in the form of an agreement between two parties owning money, and the parties to whom the funds are due. Also, there can be mineral rights. Mineral rights can be classified into can be divided as including gas, oil, gold, silver, and precious metals. Mineral rights include the right to enter or use the land for purpose of removing such minerals located therein. So there would be mineral leases and crown land leases. The Ministry of Natural Resources, in addition to the patent crown lands, grants mining leases and crown land leases. In both instances, the leases are recorded by numeric recording systems unique to the ministry. If the legal description is available, the MNR can cross-reference the information and locate property by the registry or land title description. Mining leases issued after 1940 can be found, as in case of crown patents, in official document in section of the ministry. All pre-1940 mining documents are registered in the appropriate land register office, as is the case with land leases on the crown land. Mutual drive, the strip of land shared by adjoining neighbors and used as a joint driveway by both parties, created by easement of property. There's private access. Private access is a right of entry, most commonly associated with private roads leading to the cottage or other part of rural properties. Profit pedigree is right to enter a property based on the return agreement and take something out of it, like a crop or a mineral, or maybe other wood or wood or timber that can pass with the seal of the property. And restrictive covenants is a limitation placed on the use of the property contained in the title for that property, and that can run with the land. For example, um, you can have a you can have a restrictive covenant is basically a contract between two landowners by which one person obtaining the promise acquires the right to retain the covenanter from putting the land to a to a certain specific use. Restrictive covenants has characteristics like dominant tenement to benefit the land and sufficient tenement. The covenant must be negative in nature. The covenant must directly benefit to enhance the value of the covenanter land. Both the covenantee and the covenanter land must be clearly defined. The agreement between the owner should state that a covenant is being imposed and title to both benefited and bottom land must be registered. The covenanter must be reasonable in nature and should not be arbitrary or contrary to the public interest. Historically, restrictive covenants were widely used in residential areas to regulate the use to which the land was put. Typical restrictive covenants prohibit the use of land other for anything other than the residential purpose. So restrictive covenants are usually created by express promises contained in the grant of the property to the buyer, who having previously agreed to accept land titles to these covenants. Restrictive covenants are often found in subdivision, where the owners are obligated to conform to various stipulations. These served as a forerunner for municipal bylaws. Real estate practitioners should be aware that all restrictions that affect the subdivision in which they are marketing homes, so that they can provide accurate information. Running with the land. This covenant extends beyond the origin party to the agreement and bind all subsequent owners to the liability concerning the requirements to perform on the right to take advantage of that covenant. I think with this, we're done with chapter 2. Thanks for your time. Bye.